Hello guys, today we will discuss about environmental law. The term environment is derived from the French word environment, which means to encircle or to surround. Now come to the point, what is environment? Environment is the sum of all social, economical, biological, physical or chemical factors which constitute the surroundings of man, which is both the creator and molder of his own environment. What is the definition of environment? The environment means the entire range of external influence acting on an organism, both the physical and biological and other organisms. It means forces of nature surrounding an individual. What is the degradation of environment or factor causing environmental degradation? Chlorofluorocarbon and halogens released into the lower atmosphere are drifting into the upper atmosphere and reacting with and gradually depleting ozone faster than it is being formed. The second cause is atmosphere level of heat tapping carbon dioxide are now 26% higher than the pre-industrial concentration and continue to rise higher and higher with greenhouse effect. The third one is environmental pollution, although typically associated with the industrialization, is a great and growing concern in developing countries. Use of fertilizer and pesticides pollute the environment. In the today's population, more than 1 out of every 4 live in absolute poverty. This is a cause of environmental degradation. Water is withdrawn from underground reservoirs faster than it is replenished by precipitation. Population explosive enhance the ecological demands and resulting degradation on natural resource. These are the some cause of environmental degradation. Now guys, we will discuss about what is environmental law. Environmental law is a body of law which is a system of complex and interlocking statutes, common law, treaties, convention, regulation, and policy which seeks to protect the natural environment which may be affected, impacted, or endangered by human activities. Some environmental laws regulate the quantity and nature of impact of human activities. For example, setting allowable levels of pollution or requiring permits for potentially harmful activities. Other environmental laws are preventive in nature and seeks to assess the possible impact before the human activities can occur. occur. What is international environmental law? International environmental law is the law that encompasses the entire corpus of international law, public and private, relevant to environmental issues or problems. International environmental law is merely part of international law as a whole rather than some separate, self-contained discipline. This international environmental law is nothing more or less than the application of international law to environmental problems. International law addresses environmental issues at several levels. Transboundary problems such as air or water pollution or conservation of mm, migratory animals provide example of the earliest and most developed use of international law to regulate environmental concern. International law is also addressing national or domestic environmental problems, whether through international law rights also conservation of biological diversity, protection of natural heritage area, or protect promotion of sustainable development. Now, guys, come to the point of what is the difference between national environmental law and international environmental law. Firstly, national environmental law is applicable in a particular state. International environmental law provides mechanism and procedure for negotiating the necessary rules and standards, settling dispute and supervising implementation compliance with treaties and customary rules. The second point of the difference is international environmental law is concerned with regulating environmental problems, setting common international standard and objective of prevention for prevention or mitigation of harm and providing a flexible rulemaking process that allows for easy and regular amendment in the light of technological development and advances in scientific and other knowledge. Thirdly, the national environmental law provides compensation for damages, but in international environmental law, compensation for environmental damage is more limited because only those who suffer damage can secure such redress. Whether they are states relying on international law of state responsibility or individuals relying in various ways on their right to bring transboundary action in national law. Individuals also benefit from the more recent development of environmental rights established by international law. National law will largely have to replicate the provision of these treaties and essentially be the same in each state party. While international environmentalists concede the national environmental law is flexible and loose.